ATF got their teeth kicked in and pistol braces are back on the menu. Let's talk about it. Let's get into why everybody is still here. Pistol braces. Yesterday there was a ruling that vacated the entire pistol brace rule. Not just for members of groups either. Mic drop moment. On the screen is the case that was decided yesterday. This is the Brito case. It's Darren A. Brito versus the Bureau of Alcohol, Tobacco, Firearms, and Explosives. This is the first page, and it starts with the background of the National Firearms Act. Under the NFA, the term rifle means a weapon designed or redesigned, made or remade, and intended to be fired from the shoulder, and designed or redesigned and made or remade to use the energy of the explosive in a fixed cartridge to fire only a single projectile through a rifled bore for each single pull of the trigger, and shall include any such weapon which may be readily restored to fire a fixed cartridge. Hence, a weapon that is a rifle, per this definition, with a barrel less than 16 inches, constitutes an SBR, which is a short-barreled rifle, i.e. a firearm under the NFA. Like all firearms, SBRs must be identified on a central registry, along with the identification and address of the person entitled to possess the rifle. 26 U.S.C. 5841, SBR owners must also pay a transfer tax of $200. That makes these guns safe. They're inherently crazily dangerous. Unless you pay $200, then it's fine for you to have them. A person who violates these requirements is subject to a $10,000 fine and up to 10 years in federal prison. Absent from the NFA's definition of firearms are any references to handguns or pistols, except that a pistol or revolver having a barrel with a smooth bore, designed or redesigned to fire a fixed shotgun shell, falls within the NFA's definition of firearm. Thus, common handgun and pistol owners are ordinarily not subject to the NFA. Some larger handguns, due to their weight and recoil, may be difficult to fire with one hand, especially for individuals with limited strength or mobility. For these weapons, a stabilizing brace may be attached to provide support and improve accuracy. From 2012 to 2018, ATF issued several classifications of stabilizing braces, concluding that a brace does not redesign a handgun to be fired from the shoulder. In other words, such weapon configurations were not considered SBRs. But then ATF became aware that new braces began to include characteristics common to shoulder stocks, and the evidence showed that owners use them as such. After the March 2021 mass shooting in Boulder, Colorado, where the shooter was armed with a weapon of this sort, ATF revisited the issue. Actually, Joe Biden ordered them to ban these as SBRs. On January 31st, 2023, ATF published a new rule that clarified the statutory phrase designed, redesigned, made, or remade, and intended to be fired from the shoulder. Under the rule, the phrase now includes weapons equipped with a stabilizing brace that provides surface area allowing the weapon to be fired from the shoulder, provided that other factors indicate that the weapon is designed, made, and intended to be fired from the shoulder. These factors include measurements of a weapon's weight or length of pull, the manufacturer's direct or indirect marketing, the likely use of the weapon in the general community, and whether the weapon is equipped with sights or a scope with eye relief that require the weapon to be fired from the shoulder in order to be used as designed. Because a majority of these weapons will be reclassified as SBRs, anyone in possession of a weapon reclassified by ATF as an SBR faces criminal penalties unless they comply with the NFA within 120 days of the rule's publication date, and we know that's well past by now. The plaintiffs are 3 decorated Marine veterans who possess what are likely to be SBRs under the rule. They claim the rule 1 violates the Second Amendment, 2 violates separation of powers and non-delegation principles, 3 conflicts with the NFA's definition of rifle, 4 is arbitrary and capricious under the Administrative Procedure Act, the APA, and 5 is void for vagueness. For those reasons, the plaintiffs seek an injunction prohibiting ATF from enforcing the rule. Guys, this decision is killer. Stay with me. Okay, the judge then goes into the legal standard about a preliminary injunction. Let's jump to the analysis. Plaintiffs have a substantial likelihood of prevailing on the merits, which is the most important part of the 4 factors. To satisfy the first element of likelihood of success on the merits, plaintiffs must present a prima facie case, but need not show that they are certain to win. Under the APA, courts must hold unlawful and set aside agency action, findings and conclusions found to be arbitrary, capricious, and abuse of discretion, or otherwise not in accordance with law, or in excess of statutory jurisdiction, authority, or limitations, or short of statutory right. Now, the APA is a rule-making process. However, in many cases, it's been said that the ATF's rule carries the weight of law and thus is not a logical outcome of the rule change. Thus, ATF is legislating and they don't have the power to do that. Recent precedent. This court does not begin with a blank slate. As the parties have acknowledged, the recent case of Mock v. Garland provides substantial guidance. There, a firearms advocacy group, the Firearms Policy Coalition, individual braced pistol owners, and a firearms accessories manufacturer and retailer brought an action under the APA challenging the same rule before the court now. On appeal, the Fifth Circuit held that the rule was not a logical outgrowth of the proposed rule, that the monumental error was prejudicial, and that it must be set aside as unlawful. The Fifth Circuit then remanded the case back to the district court to assess the remaining preliminary injunction factors and rule in light of the circuit panel's decision on the plaintiff's motion. In doing so, the Fifth Circuit placed no limitation on the matters that the court may address on remand and gave no indication of what decisions it should reach regarding a preliminary injunction or any other matter. On remand, the district court, which was Judge Reed O'Connor, found that the plaintiffs had demonstrated a likelihood of success on their challenge because, in addition to the circuit panel's holding that the rule failed the logical outgrowth test, the braced pistols subject to enforcement on the final rule are in common use today, and possession and use of braced pistols is therefore within the ambit of Second Amendment protection. Given the Fifth Circuit's holding, this court recognizes that the rule was not a logical outgrowth of the proposed rule and must be set aside as unlawful. That holding alone establishes that plaintiffs have demonstrated a fortiori an actual success on the merits of their APA challenge to the rule. The judge then goes into the irreparable harm part and says that these plaintiffs will fire these pistols and use these pistols and risk 10 years in federal prison, and that is substantial harm. Let's jump to the end here towards the conclusion. The court is not insensitive to ATF's concerns over gun industry gamesmanship and attempts to circumvent the NFA's restrictions on SBRs. However, the government may not simply posit that the regulation promotes an important interest to justify its regulation. Of course, some form of protest can be expected when constitutional rights are allegedly infringed. The passage of time and the development of new technology can also reveal latent ambiguities in a statute. Likewise, the court is certainly sympathetic to ATF's concerns over public safety in the wake of tragic mass shootings. The rule embodies salutary policy goals meant to protect vulnerable people in our society. But public safety concerns must be addressed in ways that are lawful. This rule is not. Conclusion. For the foregoing reasons, this court grants the motion and stays the rule in its entirety. So ordered on November 8th, 2023, Judge Matthew J. Kaczmarek, United States District Court Judge for the Northern District of Texas in the Amarillo Division. So this judge, just like others, has said that the ATF's new rule is unlawful, and it has been stayed in its entirety. So if you have a pistol brace and you use it on a pistol, and I can't actually put this on that right now because then YouTube would say I was manufacturing something, but the ATF right now has no grounds to do anything if you use one of those. and I ran one at Thunder Ranch, the entire rifle, the urban rifle class that I did. And I hope my classmates now can understand why I didn't say much when I was asked over and over again about the status, because I knew this decision was coming. And here it is. ATF, piss off, Constitution won. This will be appealed. You know that. Now here's the thing, is will the circuit court stay this decision? Mock v. Garland is still going. This is a different decision, different case in a different district, still in Texas, still been called unlawful. Use the Fifth Circuit's ruling to say as much, the three-judge panel's ruling. So now ATF is behind a really, really big obstacle. And I love it. I really do. Guys and gals, my name is Jared. This is Guns and Gadgets. Subscribe to this channel if you want more information just like this as it happens. I will keep you in the know. Thank you so much for your time. I appreciate you. Remember, be safe, stay vigilant, and carry a gun to keep you, your friends, your family, your community safe. Our rights do not come from government, period.